We're excited today to make an important announcement in the pending litigation between the District Attorney's Office and the Second Judicial District Court. As many of you know, we have had an ongoing dialogue with leaders in the judiciary about the use and, in my judgment, the over-reliance on GPS monitors as a substitute for pretrial detention. Last year, this office sought, by issuance of a subpoena, GPS records on two violent repeat offenders. One who was charged with an outstanding homicide, another individual who was identified as a serial burglar and residential property thief, somebody who we believe engaged in a pattern of conduct that really terrorized a number of residents of this community. Unfortunately, the district court declined to provide the information that was sought in the subpoena that was issued by this office. And so instead, in November of last year, we filed an inspection of public records, an IPR request, with the district court seeking historical data on those two individuals. Much to my surprise, the district court declined to accept our inspection of public records request and asserted, I think for the first time in this state, some confidentiality or privacy right for a criminal defendant who stood charged of these types of crimes and had been ordered to be subject to pretrial supervision under GPS monitoring. As a result of that denial, this office took the extraordinary step of filing a lawsuit, I think probably the first of its kind, certainly in this jurisdiction, possibly in the state of New Mexico, which sought to compel the production of those records. The purpose for seeking those records was to, number one, establish the whereabouts of these two individuals, but also, I think just as importantly, to test the legal rationale that was put forward by the courts in denying our request for access to these records. I am happy to say that yesterday afternoon, which was obviously a very busy day in this jurisdiction and in this office, Judge Jim Knoll issued a comprehensive order dismissing the court's motion to dismiss our pending litigation and granting summary judgment in favor of the district attorney's office. In short, what the district court found is that there was no privacy right or confidentiality right that defendants under pretrial supervision had in their whereabouts, which, you know, if you understand anything about this process, makes complete sense, because before a GPS monitor is actually placed on an individual, they are actually informed, obviously, that they're going to be under 24/7 GPS monitoring and supervision. We think it is particularly important to have access to these records in light of the revelations that came out last year that the district court and those responsible for monitoring the whereabouts of these individuals actually were not engaged in that activity on nights and on weekends. I am extraordinarily pleased with the decision of the district court. I would note that Judge Knoll, before he became a district court judge in the 13th Judicial District, was actually the court administrator in the 2nd Judicial District. And so he, I think, has a very clear understanding not only of the legal principles at issue in this case, but also the process by which the court engages in this type of supervision. Our hope is to gain access to these records for these two specific individuals under the court's order. We are entitled to review those records within the next 15 days. We are also, I will note, pending an argument in front of Judge Knoll about the recovery of attorney's fees for the district attorney's office, because as a result of the district court's denial of our inspection of public records request, we had to actually expend attorney resources inside of this office to litigate the matter. That's the only outstanding question for Judge Knoll to consider. Every other question and every other argument that was advanced by the district court in its denial of our GPS request has been summarily dismissed. by Judge Knoll. I do not know yet if the district court intends to appeal this decision, which it certainly is entitled to do, but I can tell you unequivocally that should such an appeal be filed by the district court, the district attorney's office, and I would hope the Attorney General's office would be committed to seeing this appeal through to its conclusion. On a last note, before I turn it over to Deputy Commander Kyle Hartsock, and one of the, I think, sadly and unfortunately, one of the better known victims in our community, Angel O'Leary, whose son, Devin Hayborn, was killed by someone who was actually wearing a GPS monitor at the time that the murder took place. I'm going to turn it over to them to offer their perspectives on yesterday's ruling. But one of the things that I think it's important to note is that in the argument of this case, and in the argument of this latest motion, there was a lot of discussion about House Bill 68, which was recently passed in the 11th hour in the legislature, and there was a specific provision, as many of you will recall, which deals with compliance for requests for GPS records. The argument put forward by the court was that House Bill 68 actually codified this rule of confidentiality, this rule of privacy that criminal defendants were entitled to. Judge Knoll didn't address that particular issue, but he also ruled definitively that House Bill 68 did not apply retroactively, meaning that even if it created some new right, that right for criminal defendants would not apply to cases like ours, which were filed before the passage of this particular piece of legislation. That being said, I don't believe, and I certainly would hope, that the legislators who crafted House Bill 68 did not intend to create a privacy right or right of confidentiality for criminal defendants, either intentionally or unintentionally, in the passage of that particular provision. I have reached out to some of the individuals who are responsible for the passage of that act. Some of you may recall that the district attorneys as a group sent a letter to Governor Michelle Lujan Grisham and asked specifically for her to line item that provision. Unfortunately, given the nature of that piece of legislation, a line item veto wasn't a measure that could have been taken. But I hope that the members of the legislature who looked carefully at this issue, but did so, I think, without the full benefit of input from law enforcement and prosecutors, will re-examine this question in light of the unequivocal ruling by Judge Knoll. What he said, in the simplest terms, is that the whereabouts of these defendants is a matter of public record, and that there is no identifiable exception to IPRA that would preclude law enforcement or members of the public from understanding where these defendants have been. The reason that's so important is that when you look at these pretrial supervision orders, a lot of times they set up exclusion zones around a victim's home or particular places that are highly sensitive in our community. But what that doesn't do is tell us anything about the movement of these individuals and whether or not they can be connected to a number of the outstanding crimes that you see on the map behind me. There are two maps displayed for you today. One is residential and auto burglary, and the other is violent crime. I think for just the last 12 months, or
year to date.
It's only year to date. What law enforcement is hoping to do is to take and gather the GPS information, not just of two defendants, but all the defendants that are currently under GPS supervision, and cross-reference those coordinates with any outstanding criminal conduct in this city. That is a common sense approach, and we would hope that leaders inside the judiciary and members of the legislature would enable us to do that. It is something that I think is a very basic step in terms of establishing real cooperation between members of the criminal justice system, and would enable law enforcement potentially to solve crimes that they haven't been able to solve to date. And on that note, I'll turn it over to Deputy Commander Kyle Hartsock to give his perspective on yesterday's ruling.
Thanks, DA Torres. My name is Deputy Commander Kyle Hartsock. I'm with the Albuquerque Police Department in their Criminal Investigations Division. I was there the night Angel's son was killed. I was actually at that scene. I was inside the command post the minute we identified the likely person who took his life or who was responsible for taking his life. Within several minutes, we identified the sheriff's department had arrested him a few months prior, and that the court had reviewed his detention, denied it, and put him on an ankle monitor. That evening, that Friday night, as we got food for our detectives, as that apartment complex was still closed, we started to try to contact the court to say, one, tell us where Devin Munford is right now, and two, tell us where he was 2 hours ago. It was denied. We couldn't do it. As we're in the command post, another shooting comes out in southeast Albuquerque. Same vehicle description, same type of gun. It was a shotgun. Everything is matching. This is probably Devin Munford shooting someone else now. In that case, it was an elderly woman over a parking dispute. She wasn't hit, but she was shot at. Now it goes into Saturday. We're still trying to get these records. We would like to arrest Devin Munford. We want to allege that he is responsible for this death. We still can't get him. It goes into Sunday. Now Devin Munford robs a convenience store off Gibson. As police show up, he runs, throws the shotgun, gets taken into custody, and finally, 2 days later, we have him in custody. With our likely murder weapon, we've now made the community a little bit safer. It would have been infinitely faster if we just could have gotten those records right away. In reality, most of the criminals that our violent crime detectives are looking for, or residential property crimes are looking for, they rarely commit one shooting and one burglary and they just stop. That's not how crime works. They're serial offenders. They do the same things over and over as opportunities present themselves. In Munford's case, he's committed 2 shootings and an armed robbery within a 48-hour period. Much like you've seen other offenders this year, they go on these sprees where they just start running rampant, causing death and destruction and terror. And we need to be able to move as fast as we can on them, especially if we identify them, and especially if we've identified there's a government-ordered GPS on their ankle. The faster we get that information, the faster we can work with prosecutors to get warrants for their arrest, work with apprehension units to get them detained, and then make that process go forward. So it took too long to even get her son's killer, alleged killer, into custody that day. We're very excited about this ruling. We hope this is the start of progress to keep this kind of information sharing more active on any types of crimes that the court is putting GPS devices on them, just like if probation and parole does it. Probation and parole puts a GPS bracelet on someone, we can get access to it if we think they're involved in something else. So we hope this continues. We're very excited about the DA's office work on this and on these 2 particular cases. One, a terrifying serial burglar who went into your house as you slept at night, which is about one of the scariest things you can think of. And 2, this individual who just decided he was going to start shooting and robbing everything in front of him over a 48-hour period. So with that, I'll give it to Angel.
Good morning, everyone. First of all, I would like to thank Roel and his team at the District Attorney's Office for the relentless efforts in bringing to light the problems within the system and fighting for the justice we need. I'd also like to thank APD and all their teams for all their hard work in making the much-needed arrests. And finally, to the judge who read through the laws and the excuses to make the appropriate informed decision. This mom is forever grateful. As a mom affected by this failed system, I need to continue to believe that my son's untimely death was for a greater purpose. That by losing him, we found out as a state exactly how flawed the system is, especially with pretrial release and GPS monitoring. We found out those fitted with GPS were hardly being monitored and how hard it is to actually get the location information. After this revelation, to add insult, I've had to listen to countless people, including elected officials, lawyers, legislatures, and citizens alike, talk about the rights of these criminals. What about my son's rights? He'll never have a chance to use those rights to fulfill the rest of his life. A life taken too soon, supposedly by someone who should have been kept in jail, but was released, and at the very least should have been monitored. I hope that this victory will not only shed light on my son's accused killer, but help solve other crimes as well. I also hope that the fight doesn't stop there, that we can use this information to show how flawed the system is and make change to our laws. We need to send a message to repeat offenders that we will no longer allow them to affect our lives. I will continue to be the voice for my son, Devin Trey Hayborn, and I will continue to fight for justice for all our loved ones lost. Please, everyone, fight alongside me and us, and let's make this state the great state that it was before. Thank you.
And with that, I would open it up to any questions that you may have, either for me, Deputy Commander Hartzog, or for Angel. Ryan?
So I'm curious right now, what does the data look like that we are getting? Is it just exclusionary zones? And when that comes in, how timely is it and how is that being used right now?
Well, this particular case only covers the two individuals that were the subject of this IPRA. And to be perfectly honest with you, the data is at this point stale. It's old. It wouldn't have been if we'd have gotten it when we first asked for it, but it's older data. Now that doesn't mean that it may not be useful. We don't know yet, for example, the location and whereabouts of, let's say, Jesse Mascarena Heidel, which I know you've reported on and others have reported on. It was the subject of an appeal and his release. He was placed on GPS monitoring, but before he was taken into custody, he was connected to dozens of residential burglaries. So we know that. We know he was placed on GPS monitor, and then months later, we know he was picked up breaking into a car at a local high school. What we don't know, and what we hope the GPS information will show us, is where was he every day between the placement of that GPS monitor and his subsequent arrest. Now, it may be, and frankly, I hope that he was in full compliance with everything that GPS had imposed on him, that he abided by the exclusionary zones, that there were no violations, and that he is not connected with any crime. But at a minimum, someone with that pattern of conduct, we should have that information so I can give it to Deputy Commander Hartzog, and he can cross-reference, for example, all the residential burglaries or auto burglaries during that time period to see if there's any link or connection between his location and an unsolved crime.
But outside of these two cases, because the ramifications of this ruling are a lot bigger than just two cases.
That's right.
Is APD utilizing GPS data right now in any way that is helpful or useful, or is this the first step into getting useful data in a meaningful time frame?
Well, up until we had this ruling, we had this ongoing legal dispute between the district attorney's office and the courts about whether or not these defendants were entitled to some privacy right that would shield this information. This ruling should clear the way for Deputy Commander Hartzog and others. Frankly, it should clear the way for members of the public, members of the media, to file their own IPRA requests with the court. Because we now have a ruling from the judge that says these unequivocally are public records that are not shielded, and they should be available for everyone to see.
Can you refresh us on the line item that the DAs wanted nixed but couldn't because it was an omnibus bill,
Right.
and how that is of concern going forward?
So the concern that we had, and if you look at the hearing that was recently argued in this case, the district court's position was that the passage of House Bill 68 actually codified, actually brought formal recognition to a pre-existing right of privacy. And they referenced a provision of that act that says law enforcement can gain access to these records if they have reasonable suspicion that it's connected to an ongoing criminal investigation. The problem with that particular framing and limitation is, in the instance of, that would solve the problem of Devin Mumford and his involvement in a particular investigation because they have independent information that places him at the scene of that crime. What if we don't have an independent lead? What if we cannot say that there's a reasonable suspicion to connect Devin Mumford to that? Shouldn't we be able to look at the GPS data for all, for example, violent criminals that are out in this community and say, we want to look to see if any other violent criminal was at this place at this time? I think the legislature intention was to make it easier for law enforcement to gain this information, but in the way it was presented to the court, it was actually the opposite. It was presented by the district court as a shield to providing this information. And I think the bottom line is that we should flag this for the legislature as an issue that says, what was your intention, right? As members of the Senate Judiciary Committee, as members of the House Judiciary Committee, what was your intention in passing this? Was it to try and make the job of law enforcement officers easier, or was it to create this right to privacy? I personally believe that the members of that committee did not intend for it to be the establishment of some privacy right where none had previously existed. But if this thing is appealed, I would imagine that that argument will resurface, and it is certainly something that policymakers should address. And I think, frankly, going into a 60-day session as opposed to a 30-day session, if they would have the benefit of the insight of testimony from Deputy Commander Hartsock, we can come before the committee and say, upon request, we would like to be able to look at, GPS location data for this time period in this place. And that is a reasonable thing to do in light of what the court has said, which is when you're on GPS supervision, you do not have a right to privacy. And I'll add one more dimension to the legal understanding of why that makes sense. We yesterday secured a conviction of Fabian Gonzalez, which many of you reported on. Fabian Gonzalez has been the subject of GPS monitoring for the last several years. Most of you may not be aware that the courts in New Mexico consider GPS monitoring to be in custody, meaning he gets to count his wearing of a GPS monitor as credit towards his ultimate sentence. If the courts in this state are going to take the position that wearing a GPS monitor is the same as custody, then we in law enforcement and we as members of the community have an absolute right to know where that individual has been at any moment during their supervision.
Fabian Gonzalez was also on a GPS monitor before he was convicted. So what do you say to critics that say, well, you're doing fishing expeditions on data for people who haven't been convicted yet, and that burden's on the government, not them?
I would point you to Judge Knoll's comprehensive constitutional analysis, and you were very right, Ryan, to be skeptical about the legal analysis that would be offered by someone who is in the system, who obviously has a very specific point that we're trying to get across. I'm not the one who made the argument about the constitutionality of this type of process. Jim Knoll did. Judge Knoll did. He looked at Fourth Amendment arguments, Sixth Amendment arguments, the right to privacy under the New Mexico Constitution. He examined all of that and rejected all of that. And so if we are all going to abide by the rule of law and what the district court itself has determined is the proper legal framework, then we should reflect on the very clear guidance that Judge Knoll gave in this case.
So specifically, where do you go from here? Do you file a bunch of IFRS today for all those cases behind you?
Frankly, my hope would be that the district court and court administrators would take a step back, look at the ruling, look at the analysis, and say, we incorrectly assumed and we incorrectly identified a privacy right for criminal defendants on GPS monitoring, and this hopefully will usher in a new era of cooperation where Deputy Commander Hartsock or members of the Albuquerque Journal or Channel 4 can submit requests for that information, and that information is provided. I don't know yet how the court intends to respond to this ruling, whether it intends to fight the ruling and appeal the ruling because it disagrees with the legal analysis, or if it's going to take the ruling as what I think it should be, is a clear signal of what the law is, and then allow people in the public and members of law enforcement to petition the court for access to the information, and then let's see if they are responsive. But we don't know yet. We haven't filed, we got this ruling yesterday, so we haven't filed any subsequent requests for information. But I would imagine that law enforcement, either here in Albuquerque, Bernalillo County, or other parts of the state, may look at that ruling and say, we want the information for the defendants that are on pretrial supervision. We want it right now.
So the man behind you that just cut off the murder suspect, can you go right now and get his GPS information to see where he's been?
That's a good question. We should be able to go and petition the court and ask for his GPS location data, but and to do so without restriction. And what I mean by without restriction is to say, give us the location data for this individual from the moment he put on the monitor to the moment he cut it off. But we may receive some pushback that says, well, we'll give you location data for his last known location because there's reasonable suspicion to connect him with a new ongoing criminal investigation, i.e. cutting off the ankle monitor. But you haven't shown us reasonable suspicion to connect him to anything else. So what entitles you to his data a week ago or 2 weeks ago or 3 weeks ago? And so what was happening with the court is there was this constant limitation placed on the request, and we don't know yet what we would be able to
You
get.
cannot cite Judge Knoll's ruling now to just say, give it to us, we don't have to show you, or is it that House Bill 68?
There is some question, especially in light of the arguments advanced by the court, and it's the belief, as I understand it, by the court, that House Bill 68 would actually permit them to restrict access to these records in a way that was not allowed when we filed this case because it came into effect July 1st of this year. And so they may cite that it is an unsettled question. My hope is that they wouldn't. My hope is that they would look at the legal analysis that Judge Knoll provided in this context. But if they didn't, then it's something that's going to have to absolutely be clarified in the upcoming legislative session.
So can we say specifically what we have done for Giannis Abreu, who cut off his ankle monitor? Like, have we, you kind of spoke in hypotheticals, and in the past, this is what we've run into. Have we asked and gotten any results for Giannis?
I can't speak to that because it's not something that's currently in the district attorney's office. It would still be something that's under active investigation, and law enforcement sometimes is not entirely in a position to detail all the things that they have done. I can tell you in a general sense that anytime we have individuals like this, I mean, this is an individual, Ralph Vasquez, who somebody was placed on GPS monitoring, was convicted. We asked to have an in-person sentencing. That was denied. He cut it off. He's in the wind and on the run. We're actively looking, we and law enforcement are actively looking for all of these individuals, but I don't know specifically what kind of GPS work has been done to try and locate them, in part because it will only tell you where they were when they cut it off, right? So it's the kind of thing that's probably useful in that context. If you're going to have a fugitive and they're going to cut it off, and if you're using just basic common sense, that's useful information probably for 5 to 10 minutes at most before they're gone from that location, because they understand that once they cut it off, it's sending a signal to the system that it's no longer active. What is more helpful for us, though, and I know Kyle can speak to this because he used to do this work in the Crime Strategies Unit, is patterns of behavior, patterns of movement. Every human being, everybody, engages in certain patterns of conduct, right? And so it may help us identify certain patterns, certain locations that are part of this person's pattern of life. And if we can look at that, it may be helpful.
Yeah, and the speed of gathering this evidence is really key too. And in this case, it's GPS data on someone who's already had a probable cause hearing. They have a lawyer representing them, and a court has found that I don't think you should be in jail, but you're dangerous enough that I'm going to put the most restrictive thing on you. And then at the point they violate or commit another crime, we just want to see that data because court, you already found they're really dangerous. I mean, you're the one who put it on there. We didn't put a GPS on them. You did. We need that now because we agree with you that we think they're dangerous, whether it's by MO of other crimes they've committed or them just escaping the custody of the bracelet. We need to understand this data, and the quicker we get it, the faster we can analyze it, and the better we can use our resources to try to get this dangerous person that you call dangerous back into custody.
That specifically relates to people who cut off their ankle monitor, but it sounds like we want to use this data to solve crimes.
Well, in some cases there might be MOs, right? I can tell you in child abduction courses, if you have an Amber Alert type situation, a stranger literally abducts a child. All the training will tell you one of the first places you're going to do, you're going to check sex offender registry list. You're going to see who's nearby. You might see what other crimes they were alleged of doing or they're convicted of doing. Does that match up with what this is? Because again, people don't change up a whole lot, right? You're going to look for those patterns. Is anything similar? Let's grab probation officers, let's grab cops, let's grab someone, let's go talk to these sex offenders just to make sure, hey, where were you at this time? We're going to go through these series of questions because a kid is missing, they were abducted, this is really dangerous and scary. We're going to check all these things off. Just like I said earlier, lots of criminals are doing this in patterns. It's not just one auto burglary and they're like, okay, that was fun, I checked off a list, I ran a marathon, I'm done. They're doing it over and over and over again and they make patterns. We want to also look at that too sometimes, especially if we have prolific problems in communities, neighborhoods, violence at parks, things of this nature. Who is there, right? That might be a witness, it might be our suspect, and again, the court is the one that put the monitor on you. They already called you dangerous. We're agreeing with their conclusion, and we want to see, did you match this crime as well?
One of the slides you had, it says unknown for the number of people on GPS monitors and unknown available. Is that really not known by the district attorney's office?
Yes, that's really not known by
Have
this.
we asked?
We have asked in the recent past. We haven't asked, in the last 72 hours, for example. But we have made inquiries about, how many people are on GPS supervision, how many monitors. But that's information that you would have to get from the court. One of the things that is troubling to me, which is separate but related to this, is that we often find that when we file a motion to detain because we believe someone should remain in custody, and the court denies that motion, oftentimes the fallback position is a reliance on GPS. So one of the things that concerns me is, do we just have enough of these monitors? Do we have enough personnel? We recently had a suspect who shot at his sister, waved a gun at his mother, was charged with aggravated assault with a deadly weapon. The judge, I think, in lieu of detention, ordered pretrial supervision by GPS, but there was a waiting list. So he had to go back to jail and wait for a monitor to come up. That right there should be a signal to the system that either we should be detaining these individuals more frequently, or if we're not going to detain them more frequently, we should massively increase the number of available monitors. And number two, before you actually release somebody and let them out of the jail, put the monitor on them while they're still in custody. Don't drive them on a bus and let them off the bus and then on the honor system tell them to go sign up for their GPS monitor, because as you know, in that case, the defendant didn't do that. What did he do? He went back to the home of his mother and his sister called this office, and this office had to call 911 to have APD dispatched to that location. And guess what he was asking for when he got there? His guns. He wanted to know why he couldn't have access to his weapons. And fortunately, investigators in this office, when he was sent to jail, went and recovered and secured those weapons and took him out of the home. What if that hadn't happened? We are getting very, very close to preventable violence by relying on this system in ways that are not properly resourced, not properly structured, and are not fundamentally built on a cooperative relationship with law enforcement.
So just to clarify, if you were to IPRA this sort of information on a particular person, are you getting real-time data on where they are now, or would you just be getting past movements based on their GPS?
Well, what you would get and this is the problem with IPRA. IPRA is actually not the preferred method for getting access to this information. And it's not the method that actually occurs in other jurisdictions. There are jurisdictions in this state where the district attorney calls up the district court or the third party that's monitoring somebody and says, Ryan's on GPS monitoring, we'd like to get his information. Sure, no problem, I'll send it to you right away. That's it. There's no IPRA, there's no subpoena, there's no search warrant, there's no discussion of all of this. I'm in law enforcement, I'm worried about this individual, and I'd like to have that information. It's only in this jurisdiction where it was a subpoena that was not granted, then an IPRA, and then think about an IPRA. We file an IPRA, many of you have filed IPRAs, then there's a long waiting period. We have to gather the information, then we give you a response. Every day that goes by is a day that is missing from an active investigation. The way this should work is someone in law enforcement should call a court administrator or the pretrial services coordinator and say, I'd like information on these 3 people, or I'd like information about this place and time, and to see if there's information that connects anyone who's under supervision at that location. Yes, absolutely. Absolutely, I understand the need for public safety, for real-time responsiveness, and we're going to give that information over. That's how it should work. Under IPRA, it's a lengthy, extended period, and it's historical.
I think what's important to note too is that this wasn't always the case. I mean, years ago, I worked cases at the sheriff's department where a person went missing and I found that they were on pretrial ankle monitor, and I could just call a pretrial services officer and I'm like, this person's reported missing, can you tell me where they are? And then they would just share it in real time. So I mean, this policy kind of came out of nowhere for no understandably any reason. It just came. And that's what was also so frustrating to law enforcement. I mean, I worked those cases back in 2014, 2015, where we could call pretrial services and get the same real-time information on a person with a bracelet as if they were on probation and parole, or if they were on CCP. There was always 3 places that gave you ankle monitors. It was MDC on the community custody program, which, by the way, if you cut that monitor off, it's a new felony. It's a crime to cut off your monitor. Probation and parole, which isn't a crime, but they'll revoke you. That's through the state of New Mexico and through pretrial services. So if ever we heard someone's on an ankle monitor, we made 1 of 3 calls to say, well, whose ankle monitor is it? We don't know. But we get the same response from all 3. Hey, what's going on? Oh yeah, cool, he's University and Central. There's a gas station right there. Looks like he's there right now. Cool. Or in the missing person case, looks like he actually cut it off and it's off some ditch bank, and that person was found deceased several days later.
It's one of those things in the system that has just emerged as a new policy or a new legal interpretation, and frankly, we don't know why. We don't know if there was a meeting of the district court judges, a meeting of the Supreme Court justices, or just a new lawyer hired at the district court that's decided that we're going to read the constitutional provisions in a new way or the requirements in a new way. But what I can tell you is that, like most of the things that have changed in the system in the last 7 or 8 years, almost universally they have not been to the benefit of law enforcement or public safety.
Yeah.
So just based on this ruling now, though, if you were granted this information on a specific individual, would you then be able to see their real-time movements? Or would it just be the past?
I don't think we know yet. I don't think we know yet.
We haven't
From pretrial
tested.
services.
We haven't tested yet whether or not the district court intends to continue to fight this, or will view it as a signal to to go back to the way things used to be in 2014 and 2015, when a member of law enforcement would call and say, "We need your help," and they'd say, "Sure." But I have every expectation that our law enforcement partners are going to test it and find
And I'll
out.
tell you it's strange because MDC, a lot of the people they put on CCP are not yet convicted. And they put them on ankle monitor, they'll share it with us, and we can charge them with a new felony if they cut their monitor off. So it's a weird difference of CCP and
So it's
pretrial
even within the
services.
same county, you have a different, right? We have different places engaged in pretrial monitoring that have vastly different procedures, and legal interpretations. And there's not a lot of clear guidance on that.
So it's the state and pretrial services that we're seeing problems with and not the MDC one right now?
Well, state probation and parole through the Department of Corrections is happy to share it with us in real time or past.
So it's just pretrial services?
That's
It's
right.
just pretrial services. The Bernalillo County and MDC is happy to share it with us, and by statute through the legislature, we can charge a new crime if they cut their bracelet off.
So is there an adversary sort of relationship between the courts and the Second Judicial District Attorney's Office right now with the type of lawsuits that we find ourselves in, and we're trying to all work for the public good here?
I think it's fair to say that we have vastly different interpretations about a great number of procedural elements inside the criminal justice system, from the elimination or reduction of the grand jury to the establishment of the CMO to pretrial release. I know you've covered a lot of those. I can tell you that when I first came into office, if someone told me that I would actually be forced to file a lawsuit against the district court to get access to GPS information on defendants that the court itself has deemed dangerous and placed on GPS monitoring, I would have said you're crazy. There's no way that someone in my position is going to have to go to that extent to get basic information to enable law enforcement to do their job. But that's where we've gotten. And my hope is that we can get to a place now where we can take rulings like this, and that rulings like this will prompt people to reconsider their policy positions about what law enforcement needs at a basic level to get the job done.
But you're anticipating an appeal.
Yes. Yes, I am. Are there any further questions that I haven't addressed? Thank you very much. I really appreciate your attendance today. Let us know if you have any follow-up questions. We'll be happy to address those.